Hey, hello, and welcome to another episode of AML Gray Matters, a webinar where we explore various issues impacting AML compliance. Today is Wednesday, 25th of May, 2022. My name is Kimberley Smith, and I am a former compliance officer and MLRO and co-founder of Silo Compliance System. With me today is two experienced experts on data privacy compliance. We have Damon Greber, and bonus, we have Kimberley Lockley with BDO. They're based in Jersey today. Welcome, Kimberley and Damon.
Hi.
Hello. I also want to welcome our audience from all over the globe. We have compliance professionals, board members, and IT professionals joining us today, which indicates how important data privacy is. But before we begin, a little housekeeping. I want to remind our audience that this webinar is not legal advice. Now, Damon and Kimberley are experienced in the realm of data privacy, but some aspects will require that you obtain formal legal advice. We will take your questions throughout the webinar, and we encourage any comments you may wish to share. Today's webinar will last approximately 1 hour, and certificates will be auto-generated and sent to you via email 1 hour after the end of the broadcast. There is one handout today, and the slides and the recording of this broadcast will be sent out on Friday. Now, also from our last broadcast, we did a drawing of our Silo cooler bag. So we pulled 3 names from the live attendees list and promised to announce the winners. In respect to data privacy, as you can see here, I didn't put their full names, but they were mailed, and I understand some are stuck in customs, so hopefully those winners will be receiving them soon. And also a very happy birthday to GDPR. Exactly 4 years ago today, 25th of May, 2018, GDPR went into effect. Damon and Kimberley, would you like to tell us a little about how you got into data privacy and a few thoughts about GDPR from your experience the past 4 years?
Sure, absolutely. And hello, everyone. Good morning, good afternoon, depending on where you are. My first delve into data privacy was well beyond 4 years ago and pre-GDPR. It was back in 1994 when I was working as a student for a data analysis company that gathered healthcare data and analyzed and put on maps. And in those days, that was on Windows 3.1. Remember those days? And identified where people with various illnesses had gone into hospitals. So the key thing there was we cannot put personal data in there. They cannot be identifiable, but we'd like to know which doctor's surgeries are referring people with potential cancer into particular hospitals and which hospital they're referring to. So that was my first foray into privacy concerns. And in those days, there wasn't a privacy law like GDPR, but there had been privacy laws prior to GDPR. And since then, I moved into technology risk consulting, which always dealt with data, always dealt with personal data. And it's around, in those days, we used to call it the CIA, the confidentiality, the integrity, and the availability of the data. But again, that was didn't really have the focus on the personal data that comes in with GDPR. My view on GDPR, it's been a totally the right thing to do, given how our lives have all changed and we now actually sell our behaviors to, for free to get access to apps on Apple and use Facebook and all of those wonderful social media tools. But the problem with GDPR is that to enforce it, it's not like having a police force and having lots of people going out and being able to force companies across the globe to comply with this. And that's always the same in compliance legislation as well. There will always be people that don't want to follow, and the enforcement actions of regulators, be that compliance or data privacy regulators, will always lag behind the capacity of people wanting to do the right thing. And I think from GDPR, actually reading through it, yes, some bits are complex, but actually take it down to its principles, and it's the right thing to do. So it's should be easy to embed. Yeah, Kimberley.
Hello, well, I'm more of a newbie, so I was, like most of us, fast-tracked into the realm of data protection compliance. My background was public sector, and like all of us who want to be honest, GDPR came around very quickly when we realised, although we wanted to plan for this, we hadn't done as much as we should have. So my background was program management and project management, and I was renowned for delivering quickly. So I had a baptism of fire into data privacy, and how I adapted is I made it personal to me. How do I want organizations to protect and respect my personal data? What do I want to know about my personal data? And once I started thinking like this, it all made sense. The GDPR is, the rights within the GDPR are human rights. And for me, that's very personal. And I kind of caught the bug. And I keep wanting to deliver against GDPR and the improvements that it's bringing in going forward, and keep learning. And my role evolved to delivering technology that technically underpinned compliance, and again, still within the realm of data privacy and information security. And thank you everyone for being here.
And I think just your point around human rights is very, very spot on. If you read the GDPR, it's interesting that some of the determinants of personal data have come from human rights. One of them is religious, and that was because what happened in the Second World War, and it's come from a background of human rights.
Yeah.
Okay, very interesting. All right. Well, before we kick off, I was going to ask one polling question, and just give me a second here to get this launched. And the question is basically, are you responsible for the data privacy at your organization? This just kind of helps us get an idea of who's listening in. Are you the DPOs? Maybe you're not even involved at all, but you're just listening in to learn more. Maybe you're in management, maybe a board member or senior management, so you're not the DPO exactly, but you still have some responsibility for it, or you're in a support role in some other way. So please feel free to respond to that. I'll give it a couple of seconds here. If you are the DPO, lucky you. I'm sure it's my experience. Coming from an AML compliance background, of course, I was kind of shoved into it, basically told, by my company at the time, you're going to be the AML compliance officer. I was like, nah, I don't really want to. And they're like, we're not asking. So I had to go out and learn very quickly what that was all about. And I have a feeling that that's probably quite a few DPOs. They were just kind of told, you're going to, handle this now. So we'll talk a little bit about that as well.
And also, Kimberley, within some jurisdictions, DPO is not a regulatory requirement. Mm-hmm. So within Cayman, it's not necessarily needed, but organisations are trying to do the right thing by putting kind of the responsibility and the learning and the quality and overview of data protection compliance activities to a person.
Yeah, and I think that's really important as well. So I've done work in the AML and compliance space historically. I think that you've got a designated MLCO individual as a key person. I think on the DPO piece, as Kimberley says, it's a mixed bag across the globe as to whether you need a named individual, but organisations are still obliged as the data controller to be responsible for it and compliant, whether or not you have to have a named person there. It's like health and safety. Do you have to have a health and safety officer? Not necessarily, but do you have to comply with health and safety legislation? Yes, you do.
Okay, fantastic. Well, you can see our responses here. We have 10% saying yes, they are the named DPO. 19% saying yes, they're responsible, but not the named DPO. 22% are in a support role to the DPO. 6% they're in IT and need to learn. So welcome to you guys. And 43% are saying they're not either no or they're unsure. So they're here to learn more. So again, Damon and Kimberley, thank you both for being here today. Let me just hide this poll here. Tell us a little bit more about what you can do and what we should know to be more compliant with GDPR and other data privacy regulations.
Sure, absolutely. So thank you for inviting us. Confusing having two Kimberleys, but I'm sure we'll get there. But no, thank you very much for asking us to be part of this, and it's always great to talk about privacy. And also feel free as we go along in the chat to bring it real for compliance officers and AML and in your day-to-day roles. So please do pop questions in as we go along. If we go to the next slide, please. So who are we? So as BDO, we offer a global privacy service. We're consultants. You can see there some stats. I'm not going to read them out specifically. But my role is in the consultancy space, and we run managed services as well. So we act as outsourced DPO for clients across the globe. We do consulting services to get their programs up and running and beginning. We do training for whole organizations or specific training for particular individuals if they're dealing with particular sets of data. And the other thing that we've done for our own purposes is we built a piece of software called Rebus to help us be compliant with our obligations, because we're a data controller. And Kimberley, who's with me, is the product manager of that, which we now sell to clients, and we use it to deliver our managed services out to clients. So through what we do from our global team, we see the challenges of cross-border data privacy. We see the challenges at a local level as well in small and medium businesses. If you take, we sit in Jersey, an offshore jurisdiction, as Cayman and others, and actually that back to your point, Kimberley, around whose role is it, and are you the DPO, and contrasting that with the compliance officer roles. There's very few organizations in offshore jurisdictions that are big enough to have full-time needs for a huge privacy team. And so it's always a challenge to sort of double hat that and see what other responsibilities that you've got. So we work with both major global institutions and small, trust companies, fund administrators, who all have got the same regulatory needs around privacy as well as AML and compliance, and they work together.
They also, with being part of a global member firm, so BDO having 164 offices, different jurisdictions, countries across the world are in different levels of maturity of either having implemented data privacy regulation on their journey to, or not yet there. So we're able to pull on our resources, our experts, data privacy experts across our member firms, to be able to assist within those jurisdictions.
Yeah, and I think that we're focused here on GDPR because it's GDPR's birthday. As Kimberley says, we've got, we work in jurisdictions that have no legislation, although thankfully that's decreasing. There's
yes,
a smaller number. But GDPR was the first of the new breed of privacy legislation. The previous legislation was, in most countries, if it existed at all, it was pay £50 and forget about it. GDPR was the first one that had teeth, had a big fining ability, and it was very clear as to what activities needed to be performed to be compliant. So you can see on the screen now that actually the fines that the regulators are kicking out are getting bigger in size. And I think what we found in the last 4 years is that a lot of the, let's say, mature European countries that have got more teeth behind their regulators, such as the Irish regulator, focusing on the Amazons, the Facebooks, and those large, primarily for American technology companies, but they're the things that we all use every day, but we have absolutely no power to keep in check. And it's the right thing that the data privacy authorities are fining them and making them,
held accountable.
Yeah, exactly. So we see there, with Amazon, there's other ones around Google, and this does compare with the antitrust and anti-competitive practices as well, and some other legislation. But essentially, we're now seeing that a lot of the larger fines are out there. They're now starting in some countries. So here where we are, and in the UK and in Guernsey, fines are coming out to smaller organizations. They've got their teams are bigger in the data privacy authorities, their enforcement teams are bigger, and they're able to now start to look at overall compliance across everyone that's registered as a data controller. And I think you've seen that in the compliance space as well. We can all think of which, particularly if you're multi-jurisdictional on the call, we can all think of which regulators are more aggressive at fining. in the compliance space and how many remediation exercises are ongoing, and we can see what their flavors are, and it's exactly the same in the privacy space. You know, some regulators will pick on certain areas, be it healthcare, be it, so in the Netherlands in particular, you know, healthcare is focused on by the data privacy authorities. Here in Jersey, people are, you know, it's financial services because there's not much other industry, to be quite honest. And each regulator has its flavor of the month and specialism.
And to Damon's point, regardless, just to strengthen that, regardless of the size of an organisation or the sector of an organisation, once you are managing, sharing, processing personal data, you can be held accountable. So it's all of our responsibilities.
And I think, and that's a good point, comes into the cross-jurisdictional piece as well. And we can see here how worldwide we've got legislation in 71% of countries and another 9 that are in draft. So everywhere's got more or less now some type of legislation.
Yeah.
There is, however, a significant challenge with cross-border. So, you know, if we talk about some of our clients that we're talking to in the Caribbean region, there are challenges in that people need to be compliant with multiple legislation. If you're dealing with EU citizens and you're a Caribbean bank or something, then actually, because you're processing EU citizens' data, you also have to protect it up to that level of standard of the GDPR. Now, what hasn't happened from the data privacy authorities is that they haven't been able yet to spend a lot of time on this. It's very complex for them to be able to enact and enforce cross-border. I think we've seen it in the compliance space with how you know, law enforcement has got ability to data share. You know, beneficial owner registers having access cross-border to you know, tax authorities and to financial regulators as well. And I think we're going to see that mature over the years in the privacy space as well.
Okay.
Yeah, I think there's yeah, exactly. There's a poll coming up.
Yeah, so here's the next poll. And this is just, again, asking our live audience, how compliant do you believe you currently are? With some options being, yeah, partially compliant with minor issues, partially compliant with major issues, fully compliant, not at all compliant, or again, maybe it's not your area, or you're unsure, or again, not applicable to you. So I think this will, I suspect this will change. We're actually going to ask this question again at the end. So I'm going to keep track to see what our answers are now. And so we're running about.
And there's only one wrong answer there. There's actually at Kimberley, there's actually only one wrong answer in those questions.
Which is, oh, not at all compliant. Yeah.
No, fully compliant.
Yeah.
Nobody can.
Look at a few people saying that they're fully compliant already. So
you see, now that is interesting. You see, the problem with privacy legislation is it moves and it flexes and interpretations change.
It matures.
Yeah, and every time your IT teams or your business lines get a new provider or something else, it's never static. So there's never a point at time where you're fully compliant. You might be in the process of negotiating a new supplier for a HR platform, and you don't have data sharing agreement in place with them. So you'll end up with, you know, non-perfect.
We have 26 full compliant. I'm presuming 6% are regulators.
Or in a country
that could be.
Or in a country
there you go.
No legislation.
Okay, but yeah, so 39% are saying some partially compliant with minor issues, 9% partially compliant with major issues to resolve, 26% are saying fully compliant, 6% are saying not at all compliant, and 20% are it's either not applicable or they're not sure. So again, thank you very much for answering that question. And let's move on to the next slide here.
Yeah, so given GDPR's birth date, we're done, aren't we? It was implemented in 2018, and there we go, hurrah! And I think it plays back to the poll as well. It was legislation that's the legislation isn't static, but it's never going to be a completed project. The starting point should always be a project to get the privacy program off the ground.
Yeah.
Do it in a structured way, and we'll talk about that in a bit, and Kimberley will cover that when we get to that slide. But also it's a roadmap of improvements, as it says. There's various things that you're never going to be completely correct to the letter of the law. And I'll give you one example. We were working with a bank, and one of the things in GDPR is that you must have a data sharing agreement with your sub-processors, which sounds great when written in legal terms, black and white on a piece of paper. Then you actually get a list of who your suppliers are. So you pay maybe for some market data, or you might pay for some AML software or well check. And you write to them and say, we want a data sharing agreement, and they're mature organizations, and they say, absolutely fine, you sign it. That's good. However, you then have a taxi supplier. You go and write to your taxi company and go, could you sign a data sharing agreement with me before I give you the address of where you're going to pick up that person, and you're not going to get a taxi to that person. So you've got a whole list of suppliers, flowers, people that do flower deliveries, people that do event organizing, where you've got to have a risk-based approach as to actually what is the data that you're going to do it. So you're never going to be 100% compliant with everyone having the right legal agreement signed on the dotted line and in place. So it is a moving journey. And getting it wrong, as it says there, there's a financial risk to it because of the fines, but there's also a reputational risk. The financial risk also, if you're a listed business, can hit your share price hard when something happens to like British Airways or other people.
3%, I think it's the Financial Times that released a fact. A private organisation who has a data breach made public in the press, local or global, their share price on average drops by 3% within the first hour.
So people care about these things because it's their data that's impacted. And then the reputational risk is also huge. And it depends on what's been lost and the nature of it. But the key thing there is that it's not it shouldn't be looked upon as, dare I use the word compliance, it shouldn't be looked upon as something that's a nasty thing that has to be done. It's actually the right thing that should do, as Kimberley says in her introduction. She said, she cared about data privacy because it was actually personal to her, what's happening to her data. I'll give you another anecdote. I went into a bank to amend a bank mandate that for a charity that I work with. And they asked me to come in and hand in my AML information, so utility bill and a passport copy, etc. Went and handed that in, and then the next day I got an email from them saying, would you mind coming in again, we've lost your information. And I thought about that for a minute, and I thought, one, why do I have to go through the pain of coming in physically to give you my passport details again? And then two, actually you're obliged to keep that secure. That's my personal data.
Yes.
And that's your personal data.
Yeah.
So I wrote back to them saying, actually, I'd like this reported to your DPO, and I'd like an answer from them as to what methods you put in to mitigate against the fact that you've lost my personal data. And I got an email back 4 hours later saying, oh, we found it again. So basically someone laid. And it was really about, it sort of brought that home that, do you know what, you don't use it as an excuse to be awkward or to have sloppy internal procedures. If people looked after my personal data properly, in line with the law, and it's the right way to do it, then actually, do you know what, I would prefer doing business with them. And so it can be a selling point as to, and we can see this in the large organizations, the IAPP conference that Kimberley and I were at in Washington just last month. We had both Tim Cook from Apple and Brad from Microsoft saying how much they care about privacy, and they were, I won't use the word desperate, but they were very passionate to try and prove to the audience and convince them that they were doing the right thing, and therefore by doing that, people, they will succeed in business more, and people will trust them better. So I think the selling point is really good there.
Yeah. It can be a competitive differentiator. If you can prove, we understand that people on this call may not be what they consider to be governed by the GDPR. But if you're following what is the gold standard, which is the GDPR, the majority of legislations across the globe are following that gold standard, except for a couple of minor nuances, then you are providing trust to your customer base and your future customer base that compared to your competitors, you are respecting and protecting their personal data, providing transparency.
Yeah. And it's getting easier as well with technology to do that. So in terms of where do people start? There's people on the poll who said that they've got work to do to become on the journey of compliance. I think we've set out there a range of key things to focus on, really. If you're required to, then obviously appoint a DPO. And it's a strange thing to say because surely everyone's done that already, but we still come across businesses that don't. So if you've got a jurisdiction where you need a DPO, there are still debates as to how do I get out of appointing one. And that's down to, in the legislation, it's about the volume and the type of data that you process. So make sure wherever you are, you know what your local legislation is, and that if you need to appoint one, you have. Just because the regulators come and knocked on your door. So it's not like, if you think about in the compliance space, depending on what your licensing is, you might have a different type of monitoring from your financial regulator. They might come in on a 3-yearly cycle and do an on-premise visit. They might send you some questionnaires, etc. The privacy authorities are not up to that level of maturity yet, but they will be. So that's coming down the line. So do get focused on privacy and make sure you're ahead of the curve rather than having to do remediation when they come in. So the key thing to get ahead is get an action plan, work out what you need to do step by step, prioritize it because you can't do it all at once, and some of these things do take a long time. And then the next one at the bottom there, lawful basis for processing. So under the GDPR, you have to say why you are allowed to process that data. So under what lawful basis? And so you need to think and document. And that's pretty much the same as in your AML space of picking up your risk ratings and why you've got a certain risk factor. Documentation is key. Why did you make that decision to say that that lawful basis was right or not? Just like, why did you make the decision that that was a standard risk rather than, or whether it needed enhanced due diligence procedures, for example. Top middle, then you got top you've got the actual, what do we do with data? And that's the key thing to know and document, and by law under the GDPR you also have to record it as your records of processing activity. So what data do we have? Where is it? How's it used? How's it secured? Now these things, I think a lot of organizations have maybe taken this a bit far and made it really complicated. They've gone to the nth degree, and I think my advice would be start at the opening side and at what your business users understand of the data that they're using, because that's the best place to get data and that understanding.
You wouldn't be able to deliver against the other requirements of the GDPR or other legislations if you didn't know what data you hold, where it's stored, how long you're going to keep it for, and who you're sharing it with. And I found out the hard way with the ropers and the data inventory, how many of us were delivering spreadsheets, long, laborious spreadsheets of all of our records processing activities with another asset register that the relationship's not linked with a supplier register or third-party processors register.
Retention schedule.
Retention schedules, and we knew we could work smarter. So I was part of a large data protection for a government program. Had the privilege of working with some brilliant experts, but again, we were delivering naively spreadsheets, static spreadsheets. Coming to BDO, we were able to, as we own an IT company, to build a system that it's a framework for completion of data privacy, which is robust. So again, going back to Damon's point, if you don't know what data you hold, where it is, how long you're keeping it for, you can't adhere to any other principles of the GDPR. You can't apply accuracy, you couldn't apply limitations, and you couldn't run any form of data minimization, just to name a couple.
Yeah, and then that goes on to actually the security of that data. So how do you know what you're securing if you don't know what you're trying to secure? And that works in cyberspace, cybersecurity itself, but that goes hand in hand with data protection. So your corporate data needs to be secure because it's your corporate data, your personal data that you process. Sorry, go on.
Yeah, I was going to say, I just have a quick question. So about the lawful basis for processing, and then of course you have the data inventory mapping. That lawful basis, do you have to have a reason for it? Like I have to have this, like for AML, I have to have AML data to comply with AML laws.
Yeah,
but I have an example. I went and bought a book at a bookstore, and they have these awards programs or discount things, but they wanted, usually it's attached to my phone number, but they wanted my phone number and my address. And I was thinking, why do you want my address? And I'm sure it's for obviously marketing purposes, but you could get my email for that. I never get anything in the actual post. So I was just kind of bothered by, they were wanting so much of my data just so I could say I'm an awards member or something, and that I thought was not necessary. And I think they need to remove that. That's my thought. I mean, do you see a lot of companies doing that, just getting more information just to have information on people, on their customers?
I think the key thing is it'll take your compliance point first. One of the legal bases is there's a legal requirement. So GDPR was never written to contradict any other existing law about what data you're allowed to collect. So if you've got your money laundering order or whatever it's called in your jurisdiction, and you need to collect that data for KYC and proceeds of crime, etc., then you say your legal basis is the law, and you write out what that law is. So you say, I need to collect it because it's this law in my jurisdiction. Then there's other ones. You've got a contract, so you might have signed a contract with your insurance company for a policy, and they need things to do various things. Employee contracts, they're quite clear. But when we get to like the example that you said, Kimberley, there is people collecting data for their own benefit, then it's harder for them to justify. And yes, loads of people do take excessive information that they don't need, and I think that is slowly changing.
It's not only the taking of, when I pop into shops, how often we ask, can we email the receipt to you? I've never ever agreed to do that, because you're not going to stand there and read that shop's privacy statement to understand that once you give this as email, we are going to share it with the whole of our franchise. We also have sister companies that sell gardening equipment, which, trust me, I don't do gardening. And so I'm not going to give them my email address, because I'm not going to stand there and read the privacy statement and agree, explicitly consent to their terms of what they're doing with my personal data.
And you know full well they want to use it for marketing.
Absolutely.
And that's the reason they're collecting it. So the thing is, it's hard. There are so many businesses out there, and they are headquartered in so many different jurisdictions, and they are, relatively speaking, small compared to the Googles and the Amazons of this world, and the British Airways and the Marriott hotels and whoever it might be. That these small companies, they're not going to get the focus from the data privacy authorities to say they're wrong, and it's up to us as citizens to be aware of that and be able to push back and just say no thanks, or no, I want to do that. But having said that, I click through stuff and say accept, because do you know what, I want to use that app, or I want to use something.
You see, I'm loving to see the journey of compliance of when you're accepting, when you get the cookies up and you're accepting what they're going to use your data for. A lot of organizations have really become quite descriptive in what you can choose to have your data. And I really do take the time to do that. I do friendly advice, not legal advice, but friendly advice is when you're asked to accept or have a read what you're accepting, what you can refuse, and you can make it bespoke to yourself.
The people are getting a lot better at it. I think there's some other additional legislation in Europe that's coming in around direct marketing on websites, which is driving the more granular cookies choices, as well as GDPR and other things. And I think it is up to us to question what we're doing. But yeah, there are people that gather more than they need to, and yeah, we're never going to get to that wonderful stage where everyone is compliant and not gathering that they you know, as you say, they should only, there's two things actually there, Kimberley. One is they shouldn't gather what they don't need to gather for the purposes. The second one is actually they shouldn't use it for other purposes.
Yeah.
So when it's gathered under the GDPR, you gather personal data for a specific purpose. You are not allowed to then use it for another purpose.
Okay.
So that might be that you gather pictures to put onto your staff, swipe tags to get into buildings. You're doing that for security. To then actually put them on their website as a marketing is to look at all the bright young sparks that we've got who work for us, that's a different purpose. And therefore you need to go back to the individuals and you would say, these are the two purposes that we want to use it for, and give them the choice to say no to either of them. So
or your lawful basis could be contract. And if it's written into the contract stipulated, this is how you use
it. Both of them.
Yes, you would.
So that goes down to actually to the bottom point there, the privacy notice, as Kimberley was saying, transparency. You know, privacy notices, God, 2018, they were given to, no offense to any lawyers who are on the call, but they were given to lawyers to write, and they were huge and unintelligible. And now we're seeing them being a lot shorter, a lot to the point, a lot more easy to read, and even, certainly I've seen it in the UK, some that are targeted and focused and written for children, because if children are using the service.
Yeah.
So I'm seeing, yeah, we're seeing that mature a lot better, and they're becoming more and more usable. I think I would recommend that. Why do you want to hide what you're doing? So some people try and make it so complex because they don't want to tell people, you know, what are you afraid of in that transparency of saying what you use data for, who you share it with.
And just to add to that, within the GDPR, it actually states that your privacy notice should be understandable to all, those that you collect data on. So I've seen animated privacy statements.
Yeah, there's some brilliant ones.
Yeah, really great where they're showing you what the other charities. We collect your data for this purpose. This is why we're doing it. This is our lawful basis. And it's in a language that all of us can understand.
Yeah.
Sorry.
Yeah.
No, that's all right.
Yeah. Okay.
So I think the other points on the side there are, you know, just keep on, you know, running it. Do you understand how you do breaches and subject requests? Who do you contact? You know, do you have documentation around your policies and what security you've got in place? And then obviously do a regular gap analysis either internally or with a third party to check, because the GDPR hasn't stayed static. Interpretation has varied, and it's got additional tweaks that come along around, you know, international data transfers, etc.
Okay.
Move on to the next slide.
The next slide. Okay.
So yeah, I think this I was thinking about the audience and the AML piece here, and you deal day to day, as you said, with data you're obliged to collect. You know, utility bills, passports. You run enhanced due diligence reports that go and find publicly available information about people's PEP status, etc. And the key thing that, from a GDPR perspective, the data privacy authorities would do if they did come in and ask, would say, demonstrate why what you're doing is right. So document your process. So within your compliance process, as well as saying how you risk rate or onboard or go and look at, you know, country risks and document that. In that procedure and policy, also document where you're storing the data that you've gathered, how long you're going to keep it for, and how long you're going to keep it for is an interesting one. You know, people go, oh, under GDPR, how long should I keep my information? And it's like, well, there is nothing in GDPR that tells you how long you should keep information for. You have to justify a reasonable length of retention. Now, it might be some other law insists that you have to keep it for 10 years of financial records in some jurisdictions, or 7 years, etc. Births and deaths are indefinite in some countries. So you have to justify it. And this is all again about having a policy statement as to how you do that, and then reviewing that and updating it on an annual basis if things change. If you use, you know, well-check overnight scans and you're getting reports out of them, where are they being stored? Are you then actually going to destroy them after the period you've stated? And that's a key one that the privacy regulators are hot on. If there's an investigation or if there's a data subject request and you provide something that is beyond your retention period, so you've said, I keep this for 10 years, and you provide something that is 15 years old,
Then
there's a dim view taken by that, and they will insist that you search harder for more information you might have forgotten to delete as well. So be bold, as it says there, about destruction, and be clear about what's okay.
And going on to your final point, the transparency of customers and their data. Again, going back to that trust element, being able to be open with the customer to say what you're doing with their data, how long, where it goes when you're finished with it, how they can exercise their rights, being really open. Provides, again, I keep on talking about this surety or trust, but it's invaluable, especially if you're dealing within the financial sector. People want to know they're protected and want easy access to the data that you hold on.
Yeah, and generally, as a financial regulated business, you're generally better than, because you've already been obliged to have security in place from your financial regulations. You're already obliged to document the internal controls, etc. So you are in a better place than, you know, private trading companies that aren't regulated at all, for example, from you know, from any sort of compliance type activities.
Okay, so we have to think about just where the data is, as well as you say, your document retention. I mean, there's a lot of moving parts.
Yes.
Oh gosh, yes.
Yeah. Your cookie statements, your client engagement letters, letting them know. So yeah, there's a lot to go on. Okay.
I mean, that's why you've got to, the first step of delivering any type of data privacy improvement program is ascertaining the data your company processes, holds and shares. And then you can start applying the other controls that are deemed within the GDPR or in your legislation to actually look at why you're holding it, how long you're holding it for, what third party you may share it with and why, how long, what jurisdiction they're in, is the security adequate in that jurisdiction. Once you have that kind of baseline view of your overarching enterprise data, you can start putting in controls and a plan of improvement. And
only when you know that you've got will you know where it changes.
Absolutely, and exactly what this slide says. You can't do, well, you know, large conglomerate with a huge data privacy team and a huge data privacy budget. Yeah, of course they can go ahead and full speed and invest everything, but in the real world, there are other priorities. For me, I've always found data privacy to be seen as a poor relative of cyber security. I always believe that there's inadequate budget assigned to data privacy compliance. So as an organization, and your regulators, I think there's ombudsman, attorney generals, they're there to help at this stage. Although happy birthday GDPR has been around for 4 years, we're all still on a journey to compliance. And as long as we can prove or demonstrate rather to the regulatory authority that we're trying and we're moving forward, they'll be there to assist you with it.
Yeah, and I think that and that matches the approach that you've got. I was just about to say risk-based approach. To, over to Kimberley on this.
Right, so as we just said on the previous slide, you can't do it all. You've got to be pragmatic with your data privacy. And the way to do that is to assess your as-is data privacy posture or compliance or maturity. And we run this as a model where we'll pop in, we use a set of standards. We're not rewriting the wheel. This has been done before. We're using the ICO 12 steps to compliance, GDPR best practice. And we will go in and run a maturity assessment on that organization's data protection artifacts, data protection procedures, policies, awareness, governance structures, and we deliver a report, a risk-based report on our findings. And that way we can start, if there is limited budget, if there is limited business resources, customer resources, we can build out a plan of a journey to have them becoming compliant while addressing the high risks in their organization. Yeah.
Next slide.
Okay.
So that just lists out sort of those steps once that assessment's been done. There's a whole range of things that might need to be, and it can be any one of these or all of these, and they need to be prioritised and budgeted for. But yeah, there's managed services where it's run. There's, Kimberley, as you said, there's lots of things to think about and lots of moving parts. But break it down into bite-sized chunks, compartmentalize it, and give accountability to someone, whether that's internal or a consultant, and move along in a nice, planned, progressive step and a journey, as Kimberley says, to compliance.
And revisit it. Once you've done, if you don't do this once, I mean, I love running those maturity assessments and then implementing and delivering against a plan of improvement to remediate these risks. And rerunning a maturity assessment a year later to see how far we've improved, and keep doing that. It's a cycle, it's a framework.
And we do that for a lot of clients where they have got limited resource, so they've got somebody who's got a partial hat as DPO or person accountable. They will say, we haven't got the SME knowledge to know where to start, so come in, do an assessment, tell us the things to prioritize on, come back in a year, we'll have worked on some of them, and then tell us what the next ones are. And then, so, we're up to the 4th year with some of our clients. Got an email through this morning from one actually saying, they come to us going, it's time for our latest gap assessment.
Having those key performance indicators at the back end of the maturity assessment and then improving upon them.
Yeah,
definitely.
Go to the next slide, please.
Well, actually, I'm going to go back to this one because I had questions originally, because I did not understand when I first saw this, and Kimberley, you were very good, and just for the sake of our audience, you might not also understand where this you call it a spider chart, correct?
It's a spider diagram, it's a tool. So what we have, and again, they're all over the world, it's been done many times before, but what we have is we have a bench parts, we have a set of standards that we will ask an organisation to provide certain artefacts, be it policy, their procedure, and looking at their data privacy impact assessments, looking at how they approach data privacy awareness and training, looking at their subject rights processes, just to list off a few. And we go in and we ask a standard set of questions against those areas. Yeah. Sorry, Kimberley, did I interrupt you? You were going to finish your question.
No, I was just so based on those questions, then you graph. Yes. Like, so for instance, this particular company, their training and awareness is a bit on the lacking side. Is that correct?
It's a number, it's not high risk. So if you look at it, it's a standard risk matrix. So you've got red, amber, green. Green's all good to go. You're absolutely brilliant. So all those people on this call that are 100% compliant, they've been in the whole green area. Yeah. When we're looking at that are on the journey to compliance, there will be areas that they've done really well in. We're not bad at everything, but there will be areas such as board awareness and training. I think training predominantly was delivered once in smaller organisations in 2018 and never again.
Yeah, so on this diagram, you look at the DPIA process and information risk assessment as a priority. Yes. Because that's got the urgent piece. You wouldn't look at your data sharing because that's mature with no concerns at the moment. That doesn't mean to say it won't change next year if the business has changed what it's doing. And this is the same as we use for like cybersecurity. The dots around the words around the outside then become the cybersecurity deliverables, ISOs, for example.
Yeah. Okay. Yeah. So I just wanted to. It does, and that's what you explained to me, and I thought it was very helpful when you and I first started talking about this to help me understand.
Absolutely. And then going back to the data privacy set. Oh, sorry, Kimberley, I talked over you. I do apologise.
Yeah, that's okay. But yeah, it just helped me understand that you're not then given this huge workload. You can say, let's focus on this. Let's focus on and then get that sorted, and then now let's go focus on this. I liked that approach.
And you can own it, and also look at our budgets. I'm assuming there's a lot of finance people on this call, that we have a budget on an annual basis. And you can only do so much. So let's take the high risk. There could be a couple of the expression is low-hanging fruit that you can deliver quite quickly against, and then take the risk-based approach to those high-risk areas.
And that's the same with compliance functions as well. If you think about compliance, data privacy, cybersecurity, we're all in the second line of defence.
Yeah.
We don't generate revenue for a business. So any programs that are there get buy-in when there is a imperative risk about failure against the regulation, be that AML regulation or be that against data privacy regulation. But you've got to get your best bang for your buck and fix your biggest holes first. Yeah.
Okay.
Yeah, so I don't think we need to particularly go on this one. Actually, it just covers sort of that splitting out of, starting with an assessment, do implementation remediation, have some operational services, whether that's in-house or out-house, and then going back round to doing the assessment again.
And having that cycle. And as we've said before, because we deliver this using our own tool, which we never built to be commercial, we built it to manage our own data privacy obligations better and smarter. We already have that cycle and framework embedded to the heart of our company.
Yeah.
Yeah. So.
Okay. All right.
Cool.
So we're moving into questions. Thank you very much. I appreciate all that. So we moved into questions. I do have a few questions. And of course, one is, can technology resolve these challenges? And I think what you're saying is it can help. And also, you need to look closely at what your technology and your systems and software is doing.
Yeah, I mean, exactly. I think you've answered the question yourself there, Kimberley.
Yeah, so fine done.
Well, I've learned from the best.
So, yeah, certain technology can help make it more efficient and easier, but it can't replace people and decision making. And it's the same in compliance. With compliance tools, you can speed up how you might do a client risk assessment, or how you might do EID and ID&V in an automated way. But actually, it's not going to stop the fundamental person who's got to decide, am I going to make that decision? Is that the right thing to do or not?
Right. And I think it also needs a question as far as when you were adopting, because people are adopting new technologies every few years and systems and looking into when you are adopting a new system, the security, and again, what's it doing before you fully sign on. So that's what I would think too, as far as people who are looking at software solutions.
Yeah, absolutely, and the privacy piece will change year on year, because software, it won't just be new software, it'll be software gets changed. You might have an update to a piece of software that changes where that data is stored, or what happens to it, or how secure it is.
And also, my background in project management, I don't believe any technical implementation is effective or survives or proves return on investment unless you have that people aspect, unless the people have been on that journey all the way through that. It's the business requirements that decide on the technologies that's going to assist them in their role, be it data privacy, cyber security, securing of the environment, or their enterprise and their architecture, or going on to that continued compliance. I mean, we talked about Robust, what we use. That's actually a framework for human, it's a framework, a data privacy framework for us to be able to work smarter. But like any system, it's only as good as the information that's in it.
And if you think about that and what you do with that, take well check that I'm sure many of you use for your compliance purposes. You can run a well check on a person and get a report, but nothing happens unless you make a decision on what you're going to do with that information.
Right.
Great.
Yeah, it's the same in data privacy.
Yeah, and going back to, as you talk about when systems change, we have silo, compliance system, and this is one of the reasons why I really like our partnership with BDO and Cayman, is because when we need to make a big change, one of the things that we have to go through is how is it going to impact the data, the data processing and things like that, and making sure we're still compliant with the GDPR and data privacy rules. So we've got your Cayman guys on helping us out and staying there, and that's something that people, especially with your internal systems, if you are a large firm that has IT guys that are making changes to your systems, they need to be involved, are aware of this as well. So this is where
challenge your providers. So yeah, challenge your providers as well, because bear in mind that they'll be changing their systems.
Okay, so I think I've kind of combined a couple of the questions here. One person did ask if a casino operating in Puerto Rico they're asking if they need to comply with GDPR if it has EU players. And yeah, I think that's
Depends if they're paying in cash or not.
What's that?
do they collect? Are they collecting their credit card details?
Yeah.
Is the casino
Yeah.
residential? Are they collating their passport details?
So possibly is the
Is
answer.
it an online casino? I mean, is that possible?
So under the gambling legislation, there are tighter controls around where the online gambling is allowed to occur. So you'll see there's some way you try and log on from another country, even if you are a client of that online casino. If you're in the UK and you do Betfred, and then you travel to the US and log on to Betfred, it won't let you play. And that's because of gambling legislation, but also privacy legislation is mixed in there again. So that's where some of these laws add complexity to it, but they don't conflict with one another.
Okay. Somebody's asking, can the DASR process be automated? DASR, what does that mean?
Absolutely. Well, DSAR, absolutely. From, how do I do this? Yes, from requests, so when the data subject or the person asks for their data, to the management of that DSAR, but it does again need human intervention. You know, you need to again to check that you're providing the person, the correct person with the information requested is who they say they are.
Yeah.
So again, the KYC and know your client comes into effect. Then also when you're actioning a DSAR and you're finding that information, it might not just be on a system. There still could be a filing cabinet. There still could be a book or paperwork. So again,
if you're Facebook, for example, the only data you have is electronic. And if you go onto Facebook and you can log on and go, give me all the
press for a DSAR.
It's got a fully automated process, and it generates a nice big zip file of stuff you will never have time to read because there's so much they have from you. But for a business like most of the, I would assume that are on the call, as Kimberley says, they're going to have, you can automate the request process,
but not
and you can automate the gathering of the data from the electronic bit, but not the manual bit. But either side of that, you need to have the manual approval and the manual redaction of what is allowed to be given back to them.
Now there are there's redaction tools, e-discovery tools, data classification tools, but I don't think any of them could be effective without human intervention.
Yeah.
Okay. I have a couple other questions. So I just went to that slide because somebody was asking to see that one again. I hope they had enough time, but everybody will get a copy of these slides and the recording. They should go out on Friday as well. We've only got a couple more minutes left. One of the questions I had asked was about DPO qualifications. If you guys felt that DPOs were kind of being qualified, and Kimberley, you were good enough to kind of provide some answers that they do need to be qualified. But in reality, of course, that role can be, as you say, downplayed.
If I can interject to that, so I don't mislead Kimberley, it is in an article of the GDPR, which is Article 37, that the DPO must be designated on the basis of professional qualities and in particular expert knowledge. Now, we've got to be honest about it, it doesn't always happen.
Right.
They have to be able to be knowledgeable within data privacy in order to enact on Article 39, which is the task of a DPO. What you see in reality tends to happen is the DPO can be given to somebody else in compliance, an AML, a dual role, and that often can be conflicted. A DPO must be report into the highest, it's the highest person of an organization, so your CEO. If you suddenly have somebody that sits within your AML or your compliance function who has a team leader they have to report to, or a manager they have to report to, how can they actually be independent?
Right. Can you outsource DPO?
Yep, is the short answer. And it's actually stated in the GDPR that outsourcing to the DPO is doable. Yes, and that's why we do it for clients.
Again, because you're non-conflicted, and because you can give independent advice. And
the multidisciplinary needs, so there's legal around contracts, there's cyber security around some of the technical controls.
Yeah, absolutely.
There's business knowledge, so that comes into that as well.
Okay. And then I had another question. It's just like if somebody said, like, we're going to call you guys, what do they need to give to you? And I think we've really covered that already. With some of your early slides. So
activity, otherwise you can't do anything else.
Yeah, exactly.
And if they don't exist, we go and do that via an interview process to begin with. You can't
a non-scary interview process.
Yeah.
All right. And any major calls? What do you say is going to happen in 10 years?
I would say that the next two things coming down the line are, well, one thing that's definitely coming down the line is data transfer impact assessments that were required from the GDPR. Cross-border is going to be a focus. So how do you manage that? Second thing, I think, is around certifications of data privacy. They were always written into the law as something that could be enacted. They haven't been yet, but there's a variety of bodies who are looking to get accredited certification schemes for data privacy. So I can see that coming down the line as well.
I am looking forward with anticipation of the Chinese Cybersecurity Act of the People, which a large part of that is data privacy. And when they start pushing that forward in regards to what they share data with, what systems they use that might not be of Chinese origin or of a country that they deem adequate. So I'm looking forward to see how that transpires.
And that's a Chinese, is that a China Act or is that an EU Act?
Yeah, the cybersecurity, but fundamentally has data privacy right in the middle of it, I say.
Yeah.
But I'm looking forward to seeing how that transpires once it sort of gets more momentum.
And I think the other thing that will come down the line is even better control of our data. So being able to delete data that people have whilst the companies, there'll be more tools out there that will actually anonymize it so that they can continue to have all of the analysis and not make the systems fall over, particularly financial systems. You can't just delete transactions because it's got a person name in it, because obviously your records won't balance. But there'll be a lot more digital enhancements.
And another thing that I can't wait to see, which I have read briefly about, is how we as people, not data privacy professionals, can start making money out of our own data. So how we can actually look at saying to Amazon, hang on a minute, I let you have this data for me and you get so much value out of it. What's in it for me?
The moment they monetize it, we get
there's movements going on where they will. I can't wait for us to be fully in control of what happens to our data and have it as a commodity where we can earn money from it, of our own data.
Oh, that'd be nice.
Yeah, wouldn't it?
There's a couple of startups and that's already. So
there are. What space?
All right. So we're at the top of the hour. There are a couple other questions about audits. What I will do though is I think maybe we need to talk about maybe doing another session just on how to deal with an audit for that, because we have run out of time. So I apologize to those who I wasn't able to get to. One last poll question. So let's see how those numbers changed. And again, thank you everyone for posting your questions, and let's just see where we are now as far as those numbers. So at the beginning of the session, we did say 39% say they were partially compliant with minor issues. 9% said they had major issues. 27% said they were fully compliant. 6% said not at all, and 20% were saying it was not applicable or they were unsure. So we will. Answers are a little bit different here, but close. So I'm going to give it a couple more seconds. Kimberly and Damon, I thought it was great. I really appreciate what you've given us today with your experience.
Thank you for inviting us.
Okay, so 13% have said they have major issues, and that is up from 9%. 52% are saying they have minor issues. That is up from 39%. 12% are now saying they're fully compliant. That is down from the beginning when 27% say that they were fully compliant. And of course, 22% saying that they, 1% are saying that not at all. That is down from 6%. So that's good. We're giving some people a bit more confidence.
Brilliant.
But so that's very good. So fantastic. Thank you. Let me hide that now. Good. Great. So before we go, I did want to say thank you to all of you who are sharing our webinar events on LinkedIn. Please keep sharing. That is helping us grow our audience and getting a bigger reach. So I appreciate that. follow us on LinkedIn as well with Silo Compliance. You'll find me connected through Silo. You can follow Damon and Kimberley as well at BDO in Jersey, and Tom Gardner. He's kind of in the background helping us as well. I am going to do another drawing, and for those Silo cooler bags, so we'll announce the winner and reach out to them. We're just going to do one this time. And again, don't forget to download the handout on Robus, some information about Robus as well. Our next webinar is on human trafficking. We have Special Agent John Tobin, and he's based in Hawaii. He's with the U.S. Homeland Security. Human trafficking is definitely a concern, especially with everything going on with Ukraine. So I had been asked to do another one on that. So I'm very excited about having John join us. That'll be 15th of June. So please keep an eye out for the registration link that will go out in your emails next week. And again, just some information about just all the different technical solutions. So there's lots out there. Of course, you got Silo to help with AML, Robus. I've seen Robus, by the way, and I think it's a fantastic system. Not coming from a data privacy background or having any of that, I was able to. Kimberly, you gave me a little demo and gave me a few days to play around on it, and I thought it was fantastic. I thought it really helped to kind of just let you know what you need to do.
Well, what it was, Kimberley, is it's built from experience. It's something that we lived and we delivered against the GDPR, and it didn't make sense. And it was like Groundhog Day. Every time you went back to deliver improvements, you were doing the same things again. And we built it to use internally. It was never meant to be a commercial model. We did it for our own internal compliance and actually thought, hang on, we're onto something here. Unlike a lot of, I mean, there's lots of software out there, but unlike a lot of software out there, it delivers end-to-end compliance. And it's your workflow that you need to follow. For me, it makes sense. I'm obviously very close and passionate about it. I'd have bit your hand off back in 2017 if it had been around then. I would have. Thank you.
Yeah, no, it's a great system. So thank you for building that, because I think it's going to solve a lot of problems for many people, especially the smaller people, smaller firms and medium-sized firms who just don't have a full-time DPO. So and that's a challenge for everybody is getting the experts in their areas. So again, here's just that list of different solutions depending on your needs. So please do reach out and request more information or demos from these people. And that's it for today's broadcast. Thank you, Damon and Kimberly, for sharing your experience and expertise with us. I know I learned a lot. Every time I talk to you guys, I learn a lot. And your passion is for data privacy is just fantastic. I think it's wonderful. And to our audience, thank you again for joining us. We know your time is very valuable. So thank you for spending some of that time with us today. Please feel free to stay on a few more minutes to watch 2 short videos. We have one on the Robus system and also one about Silo Compliance System. Until next time, this is Kimberly Smith signing off. Thank you. Demonstrating compliance with data protection legislation remains a significant challenge for business. Our specialized advisory team and technical experts have developed a data governance tool which helps clients across the organization. Not only data protection, but when reveal information about Robus is divided into 2 sections. The record and the activity. Crucially, these activities record transactions with data. Robus includes any transaction work recorded. Third, the data activity following the data activation. Very proactive.